Welcome to Session 6, and today we'll focus on intellectual property considerations, primarily intellectual property strategy, and intellectual property valuation. What we'd like to do is first take a look at the purpose of intellectual property. This will be a little different than the normal lecture you've probably heard, or at least I hope you've heard about what is intellectual property, because we're not going to cover that. We're going to cover the purpose of intellectual property and feed into the idea of a portfolio strategy. Many people have the idea that obtaining one patent is adequate for launching a product, and that's usually not the case. You need to have an intellectual property portfolio and have a strategy for managing that portfolio. This lecture is going to be extensively supplemented by the Biodesign book, Chapter 4, and it's section 4.1. It's an easy read, just a few pages. And Lecture 2 is going to address valuation and litigation to a further extent. So again, today this particular lecture, Lecture 1, is simply the purpose of intellectual property and the ideas underpinning strategy in the corporate world. Once again, we have the 3 stages of biodesign: identify, invent, implement. Hopefully you've got that memorized by now. And essentially what we are is we're still in the invent stage, where what we want to do is provide some uniqueness and assign uniqueness through intellectual property to our concepts. Interesting idea about strategic management of intellectual property. Life used to be pretty simple. The idea of intellectual property was to promote what we call the greater good. It was not intended to be of specific benefit to a company. And essentially, the creative product, intellectual property, is a creative product of a person's mind, and the law treats this intellectual property as equivalent to a real property right. And there's 4 different characteristics of 4 different types of intellectual property. Most often, when we think of IP, people think of patents, but copyrights are increasing in popularity, as are trademarks, and of course trade secrets. Now the important thing to note here is that the first 3 items, patents, copyrights, and trademarks, are federal issues, and trade secrets tend to be governed by state law, and they're contract issues. So we'll talk a little bit about trade secrets later on in the context of a state law. Again, life used to be simple. We were trying to promote the greater good, and if we think of patents, as we think of it, it was to protect the idea. Now this is pretty common to everybody. The idea is that somebody has an idea, an intellectual property, and they want to protect it, and so the Constitution allows for that. Also, the United States Code allows for copyrights, and copyrights are really to protect the expression of the idea, not the idea. So this is amended to that. And the purpose of these 2 forms of intellectual property was originally to give a business an incentive to invest in new and better goods. And the idea here is that by having these protected ideas, this would spur creativity, it would spur innovation, and again, with the limited monopoly that was provided, people would be willing to share. So all of this folds into promoting the greater good. A trademark is another form of intellectual property, and actually increasingly a value in today's market. And people value trademarks, but the idea was originally to protect customers from confusion about the source of the products. So this way, if you trademarked a product, it could not be confused with a knockoff or someone else. And of course, this was to give business an incentive to invest in information about goods. So again, we see that the original purpose of intellectual property was to protect the idea, protect the expression of the idea, and to protect consumers from confusion about the source of the products. You don't notice anything here about helping companies make money. Again, the idea was to promote the greater good, and it's an economic development incentive more so than it is about intellectual property per se. But of course, things have changed. Again, originally a trademark was to protect the consumer from confusion about the source of goods. The origin of this, of course, is in the laws of fraud and deceit. People, going back to the 1700s, a grocer could tell the customer the crackers in the bin are fresh, and this is this thing of passing off. But in fact, they may not be fresh. So again, if the grocer tells the customer the crackers in the bins came from Nabisco, there might be some quality associated with this, and therefore the customer can make a smarter choice for themselves based on the trademark. Okay? So eventually the courts endowed these companies with the rights to affix a label for the source of the goods. Again, and that created a motivation for companies to invest in consumer education about the goods, awareness of the products, avoiding confusion about the source of the products. Of course, now focus is on industry competitive position, and this idea of brand equity has crept in to trademarks, and it's about protecting brand equity regardless of whether the customer is confused or not. Of course, it does protect the producers too, and it does give them an incentive to invest in differentiating the products and brands from the competitors. But really, notice it's the brand. Brand is becoming extraordinarily popular because patents themselves are perceived to be more difficult to get and time-consuming and expensive, and basically, the knockoffs come pretty quick now. So it's just a matter of that the brand may be important in the future than patents. People will buy based on the perception of the product, not necessarily the intrinsic technical value as it might be protected in a patent. So intellectual property, it's a dynamic strategic asset, okay? This is something, and the emphasis here is on dynamic. We talk about strategy, and we talk about a portfolio that is an array of intellectual property protections, and it could be a series of patents. It could be patents plus trademarks, copyrights. Again, a portfolio, a basket of tools here, in which the portfolio is tightly integrated with the company's business plan and product development plans. So I think diminishing are the days when somebody just had an idea and they patented it. I think it's really about people conducting activities that are aligned with the company's business plan and the product development plans. So there's no question about it. A strong IP portfolio can help shut out the competition and secure a strong place in the market. Read that as a monopoly. A strong IP portfolio can increase the value of the customer of the company to investors. I think it's important here, and this is something that seems to be sort of a myth, is that you get a patent single. Rarely is a single patent or a single type of protection is sufficient. So this is why we say we really have a portfolio. We want to establish an array of protections. And this array of protections should evolve with the product line. As a product line matures, maybe you want to focus on branding more than necessarily technological patents as protecting the idea. And again, as you evolve and you develop your IP product intellectual property portfolio, you might invent something new along the way. And if you have a portfolio management team, they may help you to remember to patent really good ideas. So again, the management of the intellectual property is a corporate level strategic activity, because intellectual property is a dynamic strategic asset. It changes over the life of the product and the life of the company as well. So even things at universities have changed. It seemed that years ago universities could make little use of IP, but again, aligning with this idea that economic drivers are behind a lot of the laws related to intellectual property, the government was interested in fostering the transfer of scientific research into economic results. And before 1980, the government agency policies and procedures were very fragmented and different, and what people did, again, this relates to the recession of the 70s. Just think for a minute, in the mid to late 70s, the average the average citizen's thinking, geez, we're putting all this money into technology development, and there's all these patents out there. 28,000 patents in 1980, and only 5% were benefit. So basically what happened was that there was this thing called the Bayh-Dole Act in 1980, and what it did was it allowed universities to obtain ownership over certain innovations. So basically what happened, essentially, as a practical matter, is in 1980, when somebody at a university under federal funding developed something new and novel, and they filed a patent, the title to the patent would default to the U.S. government. That sort of Bayh-Dole Act sort of flipped things around a little bit, and it's a little bit more complicated than this, but essentially what happened is, after 1980, whatever was invented at the university, even if federally funded, defaulted to the university for ownership. And of course, this encouraged colleges and universities to develop and strengthen technology transfer, and this is why, after 1980, we had a lot of technology transfer offices created. And yes, just like all legislation that implements changes, there was a lot of fears. People thought that there'd be too many exclusive licenses leading to higher prices, again reflecting the monopoly, but I don't think we've seen that happen, and again that was a bit of a myth. And there was this idea that somehow offshore companies would receive too much benefit versus domestic. So as you would expect with any change in the law, there was a lot of myth and a lot of concern, some of it quite legitimate, but in fact none of this panned out. And indeed most people would argue that allowing the universities to have a stake in the value of transferring technology has certainly benefited everyone. Patent portfolio values fluctuate, and I think going back to what I spoke of a couple slides ago about being dynamic, strategically, things are dynamic. It's interesting that we think of a patent as a way to maintain an approved monopoly in the market. That changes with time, and the best way to look at this is this Porter's 5 forces, in which we have various industry and market issues. We've got the bargaining power of customers, complementors, bargaining power, people that can substitute one product for ours, threat of substitute products, and of course threat of entry by new competitors. So firm rivalry in a specific industry feeds off of, it's sort of a circular vortex here. You may have a strategic advantage on day one, but you can be rest assured that if you have a product and it's based on intellectual property and it's making money, you will soon have friends. You'll soon have a lot of friends. And again, feeding this cycle, you've got the threat of entry by new competitors who see what you're doing, their ability to create substitute products. Then once the market starts to grow, you've got the bargaining power of customers who are being very selective, and then people who are offering complementary products and services. And of course, once it gets to a commodity, you've got the bargaining power of suppliers. So again, this is a very dynamic process when you introduce a product into the market, and specifically you have a monopoly, which would suggest high margins, high revenue. This is definitely going to bring in friends in the business. If you weren't lonely before, if you were lonely before, you're not going to be after you start making money. A lot of people will show up at your doorstep. But again, this is a Porter's 5 forces model, simply suggesting that the clock is ticking on your strategic advantage. So, yeah, you need to maintain a portfolio. It's a dynamic, it's a corporate role, it's a strategic role, but you just can't patent everything. You've got to be selective to contain cost. So again, there's a tendency in many companies to patent everything in R&D. Not everything in R&D is worth patenting because it may not be a strategic fit. So focus is the key. You need to focus. See patent protection on what we call the core technology and the core competencies of the corporation and related functions. That's going to be the focus. Core technology is that which is key to the company's business plan, and basically non-core technology is really ancillary. I know this is a straightforward thing to say, but a lot of people spend a lot of time protecting non-core technology that the company really can't afford to support, and it's peripheral to the overall business plan, so you might as well just let it go, because in the end, you're just going to be spending a lot of money unnecessarily. So basically what you have to do is to identify the aspects of the technology that provide the greatest advantage over the competition and the greatest value over time. So I hope what you see from that is these are strategic activities. This is not just about filing the patent. So if anything, when you walk away from this lecture, I hope what you realize is that there are many different forms of intellectual property. Intellectual property is best placed in a portfolio setting where you have different types for specific reasons, and it's very dynamic. And then, in fact, you have to constantly maintain this portfolio and stay on top of it. It is a strategic function. Even do some finance. You can do risk analysis to help you make choices about what to keep. You could have the expected commercial value as a result of a R&D portfolio. And you have to understand the probability of technical success and what that means to commercialize, and then probability of commercial success. So it's one thing to have R&D that has technical success, but you've got to focus on what we think of as commercial success. And you have to be willing to make decisions along the way. When you trash it, you're basically going to abandon the patent. Expense to commercialize, you trash the prototype. Net present value, you just hope you're right. Okay, so it's going to be about valuation, and there's some standard methods for conducting valuation of intellectual property. It's kind of fascinating, actually. And so, one of the things you have to think about is, why did you invest in a technology for which you will subsequently abandon the patent? Some people will say, geez, we invested in the R&D, we got this patent, why would we abandon it? Because the probability of technical success and the probability of commercial success are not favorable to the expense of maintaining the patent. Those are hard decisions, and many people don't make them. So companies will have bloated IP protection budgets and a lot of lawyers and things like that to keep things going, when in fact they could prune their patent portfolio and be just as competitive in the marketplace. Knowing what to maintain, license, or abandon is part of strategy. So you might have something, and this is just an example, where you're going to base attractiveness of patents on business unit growth. So let's just suppose the future for your company is any domain, any market, right? Any sort of core market that's in the backdrop here, the quad, which has a growth rate of 4 times gross domestic product. Okay? And so you have current plans, future plans, not plans. So what you're really saying here is that if this is our focus, our core patents, a certain percentage of them are actually going to be suitable and complementary to any market, and with business unit growth, it's 4 times growth domestic product. So that would be your current plans. Now what you have to do is, of course, like everything else, you have to have a portfolio of strategy for your business unit development. So you can have current plans, future plans, and maybe things are such that what you really do is you want your core patents to address maybe even smaller markets as the market gets fragmented or something like that. And maybe what you're going to do is take things that are not in your plans, right? So technologies that are not in your plans, and if it's not in your plans, even if it's if it's not in your plans and it's a non-core, license it out, right? Or if it's not in your plans and it's not a core, just simply abandon it. It's hard for people to do that, but basically what you really want to do is to stick sort of in this zone and have your core patents align with your business unit growth and your corporate plans in a meaningful way. From a market perspective, the Biodesign textbook has a very nice chart. In the first edition, figure 2.4.8, we go from these market segments down to the target market, and we'll talk about marketing in session 7. But I think the idea here is that when we think of the market size and the market dynamics and the market needs and the willingness to pay, I think as you go down this, sort of go down this funnel, what you're going to realize is that it's going to take more than one patent to survive that process. All right. So not only do you need more than one patent to survive that process, you need to know what that portfolio is worth. So therefore, what we'll talk about in lecture 2 is the way in which we value the patent portfolio. So here we go. Session 6, our first lecture, introduction really to the strategic management of IP. We've talked about the purpose of intellectual property. Again, you've probably heard 1,000 times, what is IP? I know all that. Novel, useful, all the criteria. But we wanted to talk about its purpose from an economic perspective, and then talk about portfolio strategy, and underscore the idea that an intellectual property it's not just about having one patent to drive a product line. It's about a very dynamic process that has to be maintained, and it's a strategic corporate function. In Lecture 2, we're going to move on and talk a little bit about valuation of a portfolio and some of the common techniques, and then touch a little bit on litigation and some of the financial considerations related to litigation.